for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
Yeah, divorce and spousal support initiative. There's an initiative going on, Denise. What is that all about?
Well, this is in California, and this is the second time that this person, who is a divorced dad, tried to gather signatures to get the issues of divorce and spousal support on the ballot for the voters to vote. And he's trying to, okay, under California law, a spouse has a duty to support the other spouse, and at the marital standard of living, um, during the marriage that was established during the marriage. And this is both during the marriage, but also after the parties separate and are divorced. Generally speaking, that amount of money will have to go for one half the length of the marriage, unless the marriage is presumed to be long term, which is 10 years or longer. So that's the law that he's trying to change, and he's trying to get it so that alimony or spousal support, as it's also known, will only be paid 5 years. Now, the difficulty with this is right away you see under our traditional family structure, that may not be still in place today, but it still has its place today. It was the primary caretaker stayed home, took care of the kids, and didn't necessarily ever be able to achieve a career that would allow that person to live at the marital standard of living after the divorce. So our laws are designed to protect that person, whether it's a female or a male. And what I can say is a lot of times people get divorced in their mid 50s, early 60s, even sometimes later than that. And the spouse that has never been allowed to have that career, not allowed, but did never achieved a career outside of the home that would allow them to meet the marital standard of living. And I think that cutting off at 5 years is something that should not happen, to be honest. But he's got to get 623,212 registered voters by February 3rd, 2020 to qualify the initiative for the ballot.
My biggest concern about this initiative and the initiative process in general is this. This is a complicated issue about determining what should be done. And maybe alimony needs to be readdressed. I think it probably does, how things are calculated. But it needs to be readdressed, and the law needs to be drafted by folks that can sit down and actually dig into it and do what's best for all parties involved, as opposed to leaving it up to people that know nothing more about the issue than what they read on a voter information card or that little notice you get from the registrar in your county, or heaven forbid, these are the ones that really get me, the phone calls that come from one person to another as they're filling out their absentee ballot. Hey, Denise, you handled divorce. What should I do on this one? And they give no thought for it at all. The initiative process concerns me. I've seen that happen in other things in the past. This one should be fleshed out a little bit more than going about it this way.
Yeah, the good thing about the initiative process, I'll just say the other side, is that it does get the public talking about the issue. And we do need to have general discourse on these type of initiatives, and we need to have our public talking about the issues that are being presented to them.
And it gives the public a way to address something that might legally need to change when your elected representatives refuse to do it. It's just a shame that in something like this, it would maybe have to go to the initiative process when more people should really be looking at this to make sure that the law covers more of the variables.
And the person that is doing the initiative clearly has an underlying kind of bias because he basically has come out and stated, I've spent thousands and thousands of dollars on this issue at trial. So he has a particular beef at stake, and it's not necessarily, I think, well thought out that will meet most people's needs when they're going through a divorce.
I think his concern also is, at least his claim, the way he's trying to put an emotional peg on it is, well, I could pay for my kids to go to a private school with the amount of money I paid lawyers to resolve my alimony.
Attacking your spouse's alimony is not paying lawyers. I mean, when you stop and you think about it, he's actually saying that a supporting spouse should only have to pay for 5 years, even if it's a long-term marriage. And that's a very difficult sell, I think.
I think that there are things that do need to be changed. Denise, you and I were talking about this earlier today. For example, I'm divorced. When we got divorced, everything was split pretty much down the road. We didn't have an alimony issue. The custody between me and my children, 50-50. But at the time, I made more money than my former spouse. So even though it was 50-50, I still have to pay child support based upon that. And I am listed as the non-custodial parent. Now, that kind of bugs me in the sense that it sends this idea that you're not there, the kids spend 50%, maybe even more sometimes at my place in the summer because we're having a good time, but I'm listed as a non-custodial parent. That would be what they call a microaggression, something that's small, but they start to add up. I do think that some of the framework needs to be changed to represent the family dynamic that exists today, not necessarily what it was in the 40s, 50s, 60s when people got divorced and dad went from home every day to I see them every other weekend, and most of the time there's a babysitter there anyway. So it should change, but I think what he's proposing is a little radical.
Yeah, the language should change because we tend to talk about a supporting spouse or a supported spouse in the context of alimony or spousal support. In the context of child support, we're not talking about that. We're talking about custodial versus non-custodial, and the reason they have that tagline is because a marriage is not always involved. Mm-hmm. So when you have the Department of Child Support Services involved, they basically, Department of Child Support Services is your petitioner, and then your defendant is the non-custodial parent, and then the other parent is listed. They probably should not do that. They probably need to say not non-custodial, but they should say supporting parent, and they should say other parent. I think that's smarter, mm-hmm. and that avoids the tagline that I'm a deadbeat dad or that I'm not having custody of my child.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.